Welcome back, focused learners. We're jumping right into a topic that usually gives people a serious knot in their stomach, but I promise, by the end of this explainer, you're going to feel incredibly empowered. Today, we're unpacking a thoroughly detailed 2026 guide published by Olanur, written by Anita Rosebay, called How to Sue Someone in Ontario: The Real Steps, Costs, and Which Court. We're going to completely demystify the exact steps and the exact costs of suing in Ontario. We're stripping away all that intimidating legal jargon and focusing entirely on the practical roadmap, using the source's incredible data and tools to guide us. If you've ever felt completely overwhelmed by the idea of the legal system, you are in exactly the right place.
Okay, let's dive into this. Here's our roadmap. Do you have a case? The 2-year deadline, which court to choose based on the calculator, the path from your first demand to actually filing, the very harsh difference between winning and collecting, and finally, Olanur the matchmaker. So, let's start with the big question. Someone owes you money. Do you sue? It's a massive emotional pain point, isn't it? Maybe it's a contractor who took your deposit and then completely ghosted you. Or maybe it's a client who's flat out ignoring a $9,000 invoice. Or, maybe a friend never returned a loan that you both swore was ironclad. The word lawsuit just feels like this nebulous, stressful threat hanging over you. But today we're reframing all of that. We're turning that unknown stress into a series of actionable, logical decisions. Because suing shouldn't necessarily be your very first move, but understanding exactly how it works, that gives you your power back.
Do you have a case?
Well, before you even think about filling out a single court form, we need to do a serious reality check on the absolute baseline requirements of a lawsuit. For a case to be viable, you need 3 specific elements to align perfectly. First, you need a clear legal wrong, what lawyers call your cause of action. Think an unpaid debt, a broken contract, or property damage. Second, you need hard evidence. I hate to say it, but your word against theirs just isn't enough. You need contracts, invoices, e-transfer receipts, and all those crucial text or email trails. And third, and this is absolutely vital, a solvent defendant who can realistically pay you. If any one of these 3 pillars is missing, a lawsuit rarely pays off. The Olanur article gives a really great example. Imagine a Mississauga homeowner who paid a contractor a $6,200 deposit for a bathroom renovation that never even started. She has a signed quote, her bank e-transfer record, and weeks of unanswered text messages. That right there, that's a clean, provable claim with all 3 elements totally intact.
Section 2. The 2-year deadline.
2 years. In Ontario, you generally have exactly 2 years to start your claim under the Limitations Act, 2002. Now, I cannot stress this enough. 2 years sounds like a really long runway, but it vanishes incredibly quickly while you're waiting for a promised payment or just putting off all that stressful paperwork. If you miss this 2-year deadline, your case will almost certainly be completely dismissed by the court. And here's the kicker. It doesn't matter how ironclad your evidence is or how much money you're owed. Literally, if you miss the window, you lose the claim.
But when does that 2-year clock actually start ticking? The answer lies in this concept called discoverability. The clock doesn't necessarily start on the exact day the money was owed or the contract was signed. The legal principle of discoverability means the clock actually starts when you first knew or reasonably should have known that you had a claim. The start date isn't always super obvious, which is exactly why figuring out your specific deadline early on is one of the smartest things you can possibly do.
Section 3. Which court? The calculator.
So you have a case, and you're comfortably within your 2-year window. Now, where do you actually go? It's pretty fascinating how a single dollar amount, literally the exact amount you were owed, dictates absolutely everything about your lawsuit. It decides the venue, the fees, the timeline, and even who can represent you. And this brilliantly illustrates one of the coolest features embedded directly in the Olanur article, the court router calculator. This thing routes cases automatically based on the 2026 statutory thresholds. So, if you're claiming up to $50,000, you're heading to small claims court, and the filing fee is just $108. I really want to highlight that this limit was bumped up to $50,000 back in October 2025, which means thousands more everyday disputes now qualify for this much faster, simpler court. If your claim is between $50,001 and $200,000, you bump up to the Superior Court under a simplified procedure with a filing fee of $243. And anything over $200,000 goes through the full ordinary Superior Court process. Sometimes if a plaintiff is owed, say, $52,000, they might actually voluntarily give up that extra $2,000 just to stay under the $50,000 limit and enjoy the speed and lower costs of small claims court. It's a real game changer.
Section 4. From demand to filing.
Now that we know exactly which court we're playing in, what does a potential plaintiff actually need to do? Well, before you file a single official court document, your very first move should be the demand letter.
This is just a short, calm, specific written notice stating exactly what you're owed, why, and giving a firm deadline, usually about 7 to 14 days, to pay up before legal action is taken. Why do this? Because it costs absolutely nothing to send, and it actually resolves a massive chunk of disputes without ever needing to see a judge. It shows you're serious. Plus, if you do end up in court later, it proves to the judge that you acted reasonably and really tried to settle things outside of court. If the demand letter fails, though, you enter the formal timeline. First, you begin by issuing the claim. That means preparing the right form, like Form 7A for small claims, and filing it. Then, you must properly serve the defendant, meaning formally delivering the claim according to strict court rules. In small claims, you then wait up to 20 days for them to file a defense. After that, you exchange evidence, and you actually go through a mandatory settlement conference with a judge to try and make a deal. Finally, if all else fails, you go to trial. Getting these early steps right, especially proper service, is what protects a strong case before it even reaches a judge's desk. Serving someone incorrectly is literally a leading cause of ruined lawsuits, so you have to get it right.
Section 5. Winning is not collecting.
Let's say you do everything right and you win. The judge bangs the gavel in your favor. But prepare yourself for a refreshingly honest, somewhat harsh truth here. So the crucial point is, the court does not collect the money for you. What the court does is give you a judgment, but that judgment is merely a piece of paper. It's legal permission to enforce the debt. It is definitely not a check in the mail. What you must do is actually collect it. If the defendant won't pay up voluntarily, you have to take entirely separate legal steps. You might have to garnish their wages or bank accounts. You might have to get a writ to seize and sell their property. Or you might even have to demand an examination hearing under oath just to find out where they're hiding their assets. And if the defendant is judgment-proof, meaning they have zero income and absolutely no assets, you might hold a winning judgment and still never see a single dime. That is exactly why evaluating the defendant's solvency back in Step 1 was so critical.
Section 6. Olanur, your legal matchmaker. I know this whole process can feel incredibly intimidating. Even with a crystal clear roadmap, navigating forms, limitation periods, and enforcement can be a whole lot to handle. This brings us to how the publisher of this guide, Olanur, provides a truly modern solution to navigating this exact journey. But before we discuss how they help, it's absolutely vital to read the disclaimer clearly presented in their materials. Olanur is an AI lawyer matching platform and a legal marketplace. They are a technology company, not a law firm. Olanur itself does not provide legal help, and they absolutely do not provide legal advice. They are the bridge, not the lawyers themselves. It's super important to keep that distinction in mind.
So what does Olanur's platform actually do? It removes the absolute hardest first step, finding the right professional. They use their tech to match users with verified, licensed Ontario lawyers and paralegals who specifically handle everyday claims like unreturned deposits or unpaid invoices. And there's no cost for you to use the matching system. It completely removes the awful hurdle of blindly cold-calling law firms just hoping someone will take your $15,000 case, and there's no sign-up wall or obligation. You just describe your dispute once, and the technology pairs you with the exact right professional to guide you through the courts we just discussed.
We've covered a ton of ground today. You now know the baseline requirements of a real case. You know the absolute urgency of the 2-year deadline. You've seen how a single dollar amount decides your court and your filing fees using that awesome router tool, and you know the harsh truth that a court judgment is really only step 1 of actually getting paid. You know the steps, the costs, and the risks. So I'll leave you with this final thought. Are you ready to collect what you're owed? You now have the knowledge to take total control of the process. Thanks for joining me on this explainer, and keep learning.